the speech of Dr. Ambedkar. Dr. Ambedkar said, one way of doing it is, here itself we say that the governor shall be aided by the advice of the ministry, except in articles X, Y, Z. But those X, Y, Z articles are to come later in the debate. We do not know what shape they will take. So as and when we reach those respective articles, if we feel the governor has to be given discretion,
we'll revisit this article, but then it was not revisited.
That's correct. So now what happens is, when your lordship bears the discussion in relation to draft article 143 in mind, where they said that if the discretion has to be conferred, we will do so expressly in those articles. My lord, then when it comes to draft article 175, article 200, in contradistinction, what was provided originally in the draft article was in his discretion. Here, expressly it has been removed. But instead of providing it, or for your lordships to inferentially read into it, that this will have a discretion. So first, draft article 143, they say, we will say wherever the governor is granted. My lord, may I read just 163 for a minute, my lord? Article 163. Right. Very well. Then I'll just skip. My lord, then, my lord, if I may move to the next point. So, my lord, this para 2.9 deals with, my lord, the twin action, where on one hand, in 163, they say that we will provide expressly, but when it comes to article 200, my lord, it was expressly deleted. My lord, then in para 2.10, I indicate, my lord, this has also been shown to your lordships, that except in the other articles where express discretion has been conferred, with no discretion being conferred in article 200, my lord, it would not be possible to read in a discretion to the governor. My lord, then 2.11. My lord, this is the last submission on the second proviso. My lord, the second proviso, when it specifically says that the governor shall reserve the matter for the consideration of the president, my lord, where the powers of the High Court may be affected. My lord, that second proviso is actually, my lord, an indication of the fact that the governor normally would not have a discretion. He would be bound by the aid and advice.
We have already said that.
My lord, then if you
where the parliament wanted to specifically provide a discretion, it has been provided in the second proviso.
That's right.
Therefore,
but I'm only bringing one other nuance.
I assume that the parliament, the Constituent Assembly did not intend to provide a discretion in other matters.
My lord, I'm making a slightly different nuance. While it was said in the respect of various other articles, including, my lord, article 200 second proviso, I'm saying the second proviso of article 200 itself is an indication of earlier part.
So far as it affects the powers of the High Court, there is a mandate to the governor that he shall not grant.
Yes, that's correct. Obligation. There is no discretion.
Yes, I'm sure I'm not able to get my nuance across. If you just give me one more minute, madam. The point that I'm trying to make is that lack of discretion that is provided to the governor, madam, is not indicative of a lack of discretion at the governor's hands. It's a lack of discretion at the Council of Ministers' hands, my lord, where they can do something which will abridge the powers of the High Court. Because if the Council of Ministers, who normally will guide the governor on what steps need to be taken, the governor is now granted, my lord, a separate exceptional power under the second proviso, saying that here you are not governed by the Council of Ministers' advice. The Constitution enables the governor that other than the regular procedure contemplated under Article 200, where is otherwise bound by the Council of Ministers' advice, the governor here is not bound under the second proviso, even if the Council of Ministers asks him to assent or, my lord, send it back to the House at the most. My lord, he will have to reserve it for the consideration of the president. So the second proviso is indicative of the fact that the earlier part of Article 200, the governor has no discretion. My lord, then, my lord, what I have done for your lordship's kind consideration is.
What are the so-called words that you are trying to locate for the second proviso?
Yes.
For that reason. What is indicated? The governor shall not assent, that's all.
Provided that the governor shall not assent to, but shall reserve for the consideration of the president any bill which, in the opinion of the governor, would, if it became law.
In the opinion of the governor.
That's correct. So, when the governor is now mandated by the Constitution that he shall not assent to, he shall not assent to even if he is advised to the contrary by the Council of Ministers.
So his discretion will prevail over the advice of Council of Ministers.
Correct. So where they wanted this to prevail, it was expressly provided. So, the scheme of Article 200 is, if the constitutional makers felt that the governor anyway has this discretion, it need not be expressly provided by the second proviso separately. The provision is indicative of the lack of discretion in the earlier part. That's the submission I'm making, my lords. Now, your lordships may kindly bear in mind, my lord, I'm dealing with the exceptions after this very quickly. I don't need to go into detail. My lord, MP special police case has already been cited for your lordships. My lord, though it arose in the context of 197 CRPC, my lord, the Supreme Court, my lord, in para 33, my lord, a specific question fell from the court. Is the governor bound by the advice of the Council of Ministers in a statutory discretion area, like section 197 CRPC? But 197 CRPC also, my lord, this honorable court holds that ordinarily, but even in that space, the governor is bound by the aid and advice of the Council of Ministers, except in cases where the Council of Ministers itself may be disqualified on account of inherent bias, or, my lord, where the interests of the chief minister or the ministers are concerned. My lord, that is at para 33. My lord, I don't need to show this to your lordships. My lord, what I have done at the foot of the page, but after indicating the, my lord, the carve out areas made even in a statutory space at page 1327, this was also mentioned to your lordships. Vaishno Devi, my lord, Shrine Act confers powers on the governor separately statutorily. My lord, similarly, my lord, there are various state statutes which, my lord, provide that the governor shall act as the vice chancellor. My lord, there the Supreme Court Chancellor, I'm sorry. The Supreme Court has taken a view that he operates in his capacity as a chancellor.
That has also been argued.
That's right. My lord, only thing, my lord, your lordships may kindly bear in mind is now, my lord, that there is a case where your lordships have seen this possibility of a inherent bias that may be available. Some of the cases that come up, and my lord, those are cases I'm not touching on the facts of this case, but these are cases that have been decided by this honorable court. When Tamil Nadu wanted to make an amendment to the act and remove the governor, my lord, as the chancellor, replacing him with the chief minister, the governor, my lord, sits on that bill or sends the bill for consideration of the president. Your lordships may have to consider, since your lordships are acting in an advisory jurisdiction, which is much wider, I'm sorry, but whether a governor who is otherwise conferred, my lord, this separate power under a statute, if the legislature is making a law wanting to remove it, is he inherently biased in trying to sit on that bill because he will continue?
That's not a question for consideration.
I'm not that.
We will be answering what has been referred to as not
very well.
Not any hypothetical question.
Very well. My lord, then I move on to, my lord, if this is the original intent being absolutely no discretion in the governor, my lord, then should the courts, my lord, in the few areas that exceptions have been carved out are areas where the governor may not have the aid and advice of the minister if the ministry is not formed, or where, my lord, the ministry itself may be biased in, my lord, in the matter of, my lord, calling upon someone to form a government in case of a fractured verdict, those kind of situations where the governor may not otherwise have the benefit of, my lord, what is constitutionally looked at as aid and advice of the ministry. But other than, my lord, those carved out areas and special discretion conferred areas, my lord, if your lordships have to now read into Article 200, as, my lord, is suggested, my lord, by some of the council, that certain discretion would have to be read into, because, my lord, there may be situations where the governor may have to think, may feel, my lord, that it is better to have a cooling off period, or, my lord, some arguments were made that not taking a decision also could be a decision. Now, my lord, lordships are looking at a possibility. I mean, I'm only dealing with these arguments of a possibility if a lordship's doing this. Lord, lordships may kindly, my lord, notice one very important fact. At the time the constitution was made, my lord, the union in that sense, my lord, was not formed with the definiteness that we have today after 75 years of the union continuing to be there. My lord, there was a lot of tension and worry with regard to, my lord, this forces that may work towards fissiparous tendencies. So, my lord, the Indian constitution wanted to have a slightly stronger unitary center. So when it was having this stronger, slightly stronger unitary center, back then, they still felt, while we are concerned with these issues, there may be still be certain areas that can be left exclusively to the state. Now, in the areas that are exclusively left out to the state, at that point of time, they did not want the governor to have a discretion. Now, your lordships are, my lord, looking at the law after 75 years. My lord, when such tendencies are no longer as concerning, my lord, they are no longer as imminent or possible. My lord, the necessity of trying to dilute a provision against the state's interests and in favor of the governor, my lord, the necessity may actually be lesser today, my lord, because my lord, the Indian Union, my lord, by the sheer length of its existence, has gathered strength from time to time. So when your lordships look at, my lord, the situational difference between the time the constitution was made, when they felt we can have a governor for certain oversight functions, to ensure that there are no fissiparous tendencies. Even then, if the Constituent Assembly makers felt the governor's powers need to be restricted, there is no reason, my lord, to expand that role after 75 years is my submission. My lord, then what I quickly do, my lord, in my para 2.14, my lord, the other grounds that I am placing for your lordship's consideration as to why, my lord, this purposive interpretation for expanding the governor's discretion may not be correct. My lord, I indicate this will be at odds, my lord, with expressly removing from Article 200 in his discretion. My lord, reading in a discretion in Article 200 would not align with the constitutional provision of Article 163, which requires discretion to be expressly conferred. Only cases where the Honorable Court permitted a discretion to the governor and president are situations where the aid and advice of the Council of Ministers may not be available to the high constitutionally functionaries in view of a self-interest or inherent bias of the Council of Ministers or the non-existence of the Council of Ministers immediately after an election or in a case of a fractured verdict. My lord, this is another very important submission I wish to make, that though vertically different, both the president at the union level and the governor at the state level are part of a Westminster form of democracy. The governor's role under 200 would be similar to
Already argued yesterday only.
My lord, the only point, if I may add, my lord, in terms of an extra feature to this is, my lord, when your lordships look at, my lord, the areas that are carved out, the areas are separate, my lord, for the union and for the state. But in the democratic form and setup for the union, it is no different, my lord, from the democratic form and setup for a state. So if for any reason, my lord, Article 200 can be construed to mean that the governor can have the discretion to withhold or sit on a particular bill for allowing it to cool off, my lord, it would have a similar ramification for Article 111, because the president can then equally do. It cannot be that the democratic setup for the union, but where there are separate discretion, but wherever
That has already been argued.
very well.
That the role of the president and the governor are almost similar at the center and the state.
My lord, then I move, my lord, to my lord, page 1329. But again, these are the three options which, my lord, in my respectful submission are available to the Council of Ministers. My lord, I won't read through, my lord, the three exceptions except, my lord, 3.13. My lord, these have been noted both in the Constituent Assembly and also, my lord, this Honorable Court's judgments, that there may be exceptional circumstances, my lord, where the Assembly may want to reconsider. My lord, in 3.3, my lord, I have referred to Shamsher Singh's judgment, my lord, at page 1330. My lord, this para 118, Lord, is a submission that I was just making prior to this. My lord, if I may just read this with your lordship's permission. The argument about the oath of office of the president to defend the constitution is sometimes put forward by anti-ministerialist advocates. Yes, he defends the constitution not by denying its spiritual essence of cabinet responsibility. Indeed, he subverts it that way, but by accepting as his constitutional function what his responsible ministers have decided. Can a judge in fulfillment of the oath of office ignore all binding precedents and decide according to the ad hoc dictates of his uninformed conscience? Tribhuvan Das case answers the point in the negative. If every functionary who takes the oath by the constitution interprets according to his lights, this solemn document would be the source of chaos and collision, and the first casualty would be the rule of law. Such mischief cannot merit juristic acceptance. My lord, this para 123, 124, I'm skipping. My lord, this is the history immediately after the constitution, my lord, when the Hindu Code Bill was enacted. My lord, in the bold portions, my lord, your lordships would find, my lord, also at page 1331, just Sir Aladi's opinion, my lord, that throughout the, my lord, clarity, my lord, these legal luminaries had was, my lord, that the governor would have no discretion. My lord, page 1332, my lord, 3.4 summarizes my submission on this point. My lord, my contention for your lordship's consideration is what is made available for the benefit of the executive for the rare situations cannot be encroached by the government. My lord, in Nabam Arabia, my lord, this your lordships noticed, my lord, that it would not be, my lord, presumed or envisaged that a democratically elected council of ministers giving advice may be acting detrimental to the interests of the nation. My lord, what was presented, my lord, in terms of argument was if the ministry were to do something that is against the interests of nation. My lord, that is something, my lord, that is normally not presumed, but if a particular fact situation emerges, my lord, that would be dealt with in terms of the constitutional provisions. My lord, then reference to the president, my lord, was broadly already touched upon yesterday, so I can move very quickly there. My lord, Mr. Datar had argued this, but my lord, something very important for your lordships to consider is that para 3.9. My lord, the Sarkaria Commission, my lord, notes this as a necessary channel. But if I may just read this part, the constitution makers noted that articles 200 and 201 are also necessary in view of clause 2 of article 254. This needs a little amplification. Matters enumerated in the concurrent list are of common interest to the union and the states. On the basic aspects of such matters, legislative uniformity throughout the country is desirable. However, if Parliament occupies the field of concurrent subject, the power of state legislature to enact a law on that subject is in variance with the union law is practically taken away. This results brought in about by the operation of the rule of repugnancy contained in clause 1 of article 254. Nonetheless, peculiar conditions, problems and practices relating to that subject in a state may need regulations and remedies quite different from the one provided in the union law. In such a situation, a legislation of the state legislature making provisions suited to the peculiar conditions in the state, though inconsistent with the union law, can be saved from invalidation on the ground of repugnancy if, having been reserved by the governor for the president's consideration, it receives his assent. Thus, articles 200 and 201 provided a necessary channel through which clause 2 of article 254 operates to save the powers of the state legislature from being unduly abridged by the rule of repugnancy. My lord, on the aspect of presumption of good faith, my lord, I have already made my submissions yesterday. So, my lord, I'll skip it, my lord, in the interest of time. My lord, only, my lord, at para 3.14 and 3.15. My lord, normally, your lordships recollects, my lord, if it is reserved for the consideration of the president under article 200, under 201, it goes before the honorable president. The honorable president, my lord, would have the power to ask the house to reconsider and send a message. But if it is sent back, it is again presented, my lord, before the honorable president for consideration. It does not say he shall mandatorily assent. And my lord, there's a good reason for that. Now, when the president does not grant assent, my lord, now typically, my lord, these situations arise when there is a conflict. My lord, the center makes a law throughout the country. A state in a particular geographical area may want to make a slight departure. My lord, it sends the bill to the honorable president, my lord, for the purpose of consent or approval. If the approval is granted, my lord, these provisions of the State Act will take effect within that geographical limit. But if approval is denied, my lord, then those central law provisions will continue to operate. My lord, this is a net effect. But my lord, when the bills are sent, my lord, the president as a practice either declares, my lord, that assent is being granted or assent is being withheld. It would not be kept pending. But when the honorable president may have taken time, they enable the state to know that assent is being withheld so that, my lord, the state can then work out its affairs. But yesterday I had mentioned, my lord, suppose if my lord, lordships looks at this as something that is likely to arise, my lord, because that is the anvil of your lordship's consideration, not purely hypothetical. Several acts, my lord, may be in a particular state area or it may be in a concurrent area. If a special law is made, my lord, for protection of women, my lord, lordships looks at this situation. It then says in relation to any offense relating to women, anticipatory bail may not be available. Now, this may be, my lord, repugnant to section 438 old of the CRPC. Now, this provision, for it to become effective, it may have to come up, my lord, for consideration before the president by reference. If the president were to grant approval, my lord, then that non-application of 438 would come in relation to this other law made by the state. If the president were to deny, I'm giving a very simple example. If the president were to deny, then 438 bail provisions would continue to operate. But assuming either situation, approval is granted or approval is not granted, all the remaining provisions, my lord, in relation to protection of women under a special law made by the state would otherwise be operative. It may just be this one part which may need the consent of the president. So, my lord, if this is granted, it operates one way. If it is not granted, it may operate in a different way. But if the bill is kept pending without, my lord, saying whether it's assented to or non-assented to, the bill can never become the law. My lord, therefore, my lord, what I have also,
What do you want to, what is your proposition?
my lord, the proposition I was making was that when a bill is sent to the Honorable President for consideration, while it would be within the discretion of the President in relation to certain subjects where, my lord, consent approval may be granted or may not be granted, there has to be a declaration indicating whether assent is being granted or assent is being withheld. And in convention, my lord, the President always, my lord, makes a declaration saying that assent is granted or assent is withheld. It can never be, my lord, a constitutional black hole that a bill remains pending without.
Doesn't work like that. 250. We are still in the realm of 200 and 201.
201.
201, when the law is not made. Once the law is made, operation of 254 will come in. If it is a conflict with central law, it's null and void, subject to sub-article 2. The law is made, 254, it's law. That's why, see the provision 254 say, if the provisions of a law, that is, there is a law already. So 254 won't apply here. We are in the realm of making of law. At the time of making of the law, the power of assent, the power of withholding, the power of grant. So it's in a stage where law comes into operation.
My lord, there may be two ways of looking at it. My lord, I understand what's falling from the Honorable Bench. One is when the bill is made, if, my lord, the Council of Ministers feels that some of these provisions of the bill may be repugnant and therefore may not be operative unless the President's consent is obtained. At the bill stage, my lord, it can be referred under 201. If 201, the President grants approval, then it becomes a law. 254 will not make it repugnant. But the other way of doing it is the state legislature can request the President to grant assent, make it a law, and then because repugnancy will make the other provisions unworkable, request the governor to send that part of, my lord, but once a law is made, it might be difficult, my lord, for it to be sent to the President thereafter. So, my lord, in my understanding, subject to correction, at the bill stage, my lord, usually 200, 201, it goes before the President. If the President grants, my lord, approval, then, my lord, it becomes a law. Equally possible, my lord, I'm dealing with it in the justiciability part of my submissions, that the President may, after being advised, my lord, by the Union Council of Ministers, say, no, we want to have a uniform policy throughout the country, not in a matter like Essential Commodities Act. We are not agreeable to this state having a separate, my lord, legislative environment in a particular geographical area. So if the President refuses on the advice of Union Ministers, my lord, then the central law will continue to operate by virtue of 254. My lord,
What you have suggested in 3.13 to 3.15 is inconsistent with what has been argued from your side.
no, my lords. My lord, yes.
Probably study you are not clear, that's why.
No, my lord, if I
You
may.
are insisting for a formal declaration, the argument was otherwise. We are only pointing out that from your side. The argument was that there is no requirement, there is no concept of a formal declaration.
Formal declaration of withholding of.
Yes.
Correct. Yes, my lord. Some of the states have made that submission, but my submission
You have
is,
completed your 45 minutes.
my lord, another 10 minutes, I'll finish, my lord.
No, but then we have to.
Yes, my lord.
We have to.
No, just 10 minutes. I'll very quickly run through this. But page 1335, what I have done, Lord, I'll not read this now, note for your lordships. Lord, what I have done is this power under Article 200 and 201, or the, my lord, the provisions would have to be operated, my lord, in relation to the three lists separately. If it's a union list, my lord, the union list, Article 246(1) itself says that the power to legislate is exclusively vested, my lord, with the Parliament. So state cannot make a law in relation to union list. So, my lord, if a bill is passed by the state legislature in relation to a union list, my lord, there would be no power available to the state legislature. It's ipso facto invalid. It will be void ab initio. If needed, a court will declare it to be invalid. Now, this does not require the governor to exercise discretion either to send it back to the house or send it, my lord, to the president for consideration, because the president also cannot grant consent for making it valid if it is entrenching into list 1. So if list 1 is something that does not require this method of referring it to the president, it will not be applicable. My lord, if it is a state list exclusively reserved, 246(3), exclusively reserved for the state, my lord, the union parliament, my lord, ordinarily would not have any power, my lord, to legislate on those particular areas. But what I have done, my lord, at page 1336, my lord, I have indicated, and I'm not reading this, my lord, that the constitution itself makes provisions that whenever, my lord, the constitution wanted the power of the state to legislate to be subject to the union's power to legislate in legislative field areas, my lord, there are a series of articles which my lord's entries, my lord, at page 1337, where in list 2, my lord, the legislative field itself is made subject to the union's power to legislate or subject to laws made by the union in this particular behalf. So legislatively, while they carved out certain area for the state, within the carved out area, my lord, they also had certain caveats with regard to where the state, my lord, the center can come and legislate. If it is otherwise left to the state, my lord, legislatively, it is for the state legislature to make this law completely on its own. If such a law is made, the governor cannot sit in judgment and say this is either not desirable or the current circumstances do not make it feasible for having this particular law at this point of time. There is no point of referring it to the president under Article 201 in relation to a state subject, because the president and the union also in the executive sphere have no power to stop a state from legislating on a state subject. My lord, the constitution was mindful that there may be situations when the union parliament may have to be given power to legislate on state subjects. My lord, at page 1338 onwards, my lord, Article 249, 250.
When some of the states make a request jointly.
Correct. My lord, also, my lord, Article 250, my lord, if proclamation of emergency, 252, when two or more states request. My lord, also, my lord, 253, to giving effect to, my lord, any international treaty. My lord, I have set out all these articles in my note. Now, this enables, my lord, that the parliament in its legislative space can make a law in respect of a state subject area. So if parliament, my lord, can do it, it may do so, and it will be for a limited period of time. The constitution was mindful, my lord, in which circumstance it will extend for which period of time, unless, my lord, it is where more than 2 states are asking for it to be done, or the council of states by 2/3 majority request the parliament to do it for entire India. So, my lord, if in the parliamentary space, legislative space itself, if the center cannot, my lord, infringe on the state's rights to legislate, in list 2 subjects, my lord, my respectful submission is the governor, my lord, either cannot withhold for the purpose of reconsideration or send it to the president. My lord, the only other area would be, my lord, the concurrent list area. To avoid this repugnancy, I've already made my submission, my lord, that this concurrent list area, it would be, my lord, at the request of the Council of Ministers. Even if the governor were to find, Council of Ministers thinks, my lord, it is not entrenching into any central subject area. The governor were to form an independent mind that this may entrench, it may need consent. But he is not sitting in judgment on the legislature's views or wisdom, because he would then have to give assent. If it has to fail, it will fail on the anvil of, my lord, judicial review proceedings that may come up before the court. So for all the 3 lists, when your lordships were to look at it separately, but Article 200 does not enable the governor to either withhold assent for the purpose of reconsideration or sending it to the president. Sending it to the president, my lord, the governor cannot, as I use an expression, my lord, extra constitutional advisor to the state legislature. When the state legislature says, no, it doesn't, my lord, trammel into the central government's legislative sphere, say that, no, I think it does, and refer it to the president. My lord, then justiciability is one last aspect, very quickly, my lord, I'll touch upon. My lord, page 1342, my lord, when a bill is sent to the president, in relation to, my lord, a concurrent list area or the other provisions of the constitution where the consent of the president is needed. My lord, if the president, my lord, feels on the advice of the union ministry that it is not desirable, my lord, judicial review in my respectful submission is permissible. Because what happens, my lord, if the president were to grant assent to state A for an identical provision, but were to say, I will not grant it to state B for an identical provision, my lord, then it would touch upon the aspect of discrimination. In a judicial review space, my lord, the court may interfere with it. But on justiciability, suppose, my lord, the governor were to say, no, we feel we need to have a uniform policy, or the conditions in this particular state are not enabling the union to have the confidence that there can be a departure from the central law. My lord, that on the fact situation would be dependent upon those factual situations where justiciability may be difficult. So it cannot be, my lord, one common situation where it is not justiciable. Judicial review is permissible. Justiciability depends on a fact-to-fact case and a situation-to-situation basis. My lord, I have just made this submission in 3 parts. My lord, last submission, my lord, on timelines. My lord, it's already been covered, but I'm only submitting, my lord, that in terms of your lordship's advisory jurisdiction space. My lord, since the my lord, the presidential reference has been made with specific questions on this point. My lord, if your lordships were to form a clear opinion that this has to be done with expedition and this is to be done within a particular time frame, my lord, that is, as I indicated yesterday, your lordship's view of how time frames or whatever time is a reasonable time for the exercise of discretion, that would still be your lordship's advisory opinion. But that advisory opinion, my lord, in my respectful submission would be binding on the president and instructions would have to go to the governor. My lord, only 2, my lord, yesterday I had mentioned about this judgment. I'm not reading it. If my lords would want to make a note. My lord, in that special references case, 19, my lord, this is at volume 5.9, page 3661. My lord, just 3 paragraphs, my lord, I'm requesting your lordship's attention to.
Where have you referred to in your note?
My lord, this is there, my lord, in 6.1. No, my lord, this is not a part of my note. I had referred.
Volume?
Lord, volume 5.9. Lord, page number 3661 is a citation, my lord, of 1979, volume 1 SCC 380. Lord, just 3 paragraphs, my lord, I am requesting your lordship's attention to. I am not reading it. Para 21, para 32 and 34. My lord, this 32 and 34 have not been read for your lordships.
On what issue?
My lord, this is with regard to, my lord,
Timelines.
para 21 is on a bill that is yet to be made. Para 32, 34, my lord, deals with how, my lord, there will be no encroachment into a legislative space by your lordships. If your lordships were called upon to render an advisory opinion and your lordships render an advisory opinion. So today, Article 200 and 201, apart from timelines, your lordship's opinion is sought on whether there is a discretion available to the governor, whether the discretion available to the president, in what measure is the discretion available. My lord, questions are also asked, are they justiciable? My lord, then the last of the questions is, are there any timelines that would be governing? So, my lord, my respectful submission is, staying in the space available to the president and the governor under Article 200 and 201, they are seeking your lordship's opinion. Since they are seeking in the space available to them, at their invitation, it is fully just and open for your lordships to give this opinion, which might be binding on them in terms of, my lord, your lordship's review. My lord, I'm grateful.
Thank you.
My lord, I had mentioned about that notes to the Constituent Assembly. If I may just give the page number, it's 9312. The relevant part I've already extracted in my note. But just one last submission before my friend takes over. My lord, we have had tremendous assistance from the nodal council, but I can figure out, my lord, with the quality of assistance they have given, there have also been a lot of costs they have personally incurred because all the volumes being filed into the court are being filed by them at their expense. And when we offered to pay costs, they said no, unless there is a formal order, it would not be possible for us. Lordships may.
Yes, my lord, I can vouch for both the nodal council of other side and my council, my lord. It is, my lord, a labor of love, my lord. Nobody would like to charge. It's an assistance to the court, and it's, my lord, and
No, not fees.
expenses. Even expenses also.
Volumes and printing of so many volumes.
That's all right, my lord. It's an honor to be a nodal council before the highest constitutional court of the country. And the amount also may not be more. And I'm speaking for.
It can be distributed by the state and all the governments.
My lord, I undertake the responsibility. Your lordships need not, my lord, bother. It's a small thing.
And we'll.
Of this, one council's appearance can bear the expenses. What is the problem there? Why should even this be? Mr. Simple is there, Mr. Reddy is there.
I take the responsibility.
Is there, Dr. Singh is there.
No need to.
Mr. Mehta is there.
My lord, I am taking the responsibility for the
I'll
expenditure
bear the
of
cost,
both.
my lords, on this side.
Yes.
No, this side, that side, I'll take the
I'll
responsibility
bear
with.
it on that side also, no issue.
No. I know you, Mr. Symbol is.
Far as the nodal council this side, but
No,
I
Mr.
myself have
Symbol is
written
very
to the Tamil
generous,
Nadu government
but
to sanction and pay.
No, don't, let's not get into this.
Yes. My lord, that, my lord, I'll take care of, my lord, for both sides. Your lordship need not bother. But it's very kind of Mr.
Ready.
Mr. Reddy, my lord, to have flagged this issue. That's all.
Lords, if you just look at my note, it is in volume 2.13.
He's appealing for the state, so.
State, I have to be heard first.
But what are you going to argue? If you are going to toe their line, then we will not listen you from this.
No, we have certain different points. Your Lordship, the Lordship kindly see three provisions of the Constitution. Article
We
244.
are going by the sequence.
Let him pause the states and then only the interviewer.
I have something to say. My lord, I am not objecting to anybody arguing. But if your lordships are permitting even, my lord, strangers, my lord, to the issue being argued, my lord, I would personally feel, my lord, that let Mr. Wilson also have his day, my lord, for 10-15 minutes. He at least represents a political party which has a government in one state.
Grateful
But
to my.
individuals who have nothing to do are coming before your lordships and are, my lord, getting your lordship.
Lordship, individuals have to do very much,
My learned
and we can say in this constitutional.
My lord, you have right.
Eventually, the citizens won't get hurt while this political battle goes on to and.
No, nothing like that. Lord,
No,
we
but
have-
there are.
Lordship,
there is a-
Constitution, the document will define the politics
One
of the
minute,
country.
Sharma, 1 minute. 1 minute, Mr. Sharma. Don't raise your voice.
No, sir.
We'll run 10 minutes each.
Yes,
Oblige.
yes.
Obliged, Lord. Kindly see, my Lord.
I have a petition.
My lord, stranger in the sense, my lord, this is, my lord, state governments, etc., my lord.
Let it, it's okay.
Therefore, my lord, it was my duty, my lord, to say that if others are hurt,
No, we are-
Mr. Wilson also.
We are going to hear Mr. Wilson also. Because if you are going to permit the other interveners, then.
Therefore, my lord, he could not have said it again.
And particular-
Therefore, I am saying.
And particularly when the live streaming is going on, so.
No, my lord, no.
Many of the arguments are only for the sake of live streaming. If we stop the live streaming,
Crowd will listen. My lord, I reserve my response, my lord, outside the court, my lord. But I have a very good response.
Your Lordship, the Article 244 of the Constitution, my Lord, kindly see, because tribal
you are
area.
appealing for Meghalaya.
I'm appealing for Meghalaya, state of Meghalaya, my Lord. Because there are certain unique features in 6th schedule and Article 244 conferring certain powers to the governor, my Lord, which will have bearing, my Lord. Two 44, Article 244, sub Article 2, my Lord. The provisions of the 6th schedule shall apply to the administration of tribal areas in the state of Assam, Meghalaya, Tripura, and Mizoram, my Lord. So this Article 244-2, my Lord, leads to 6th schedule, my Lord, and 6th schedule, your Lordship will see certain powers have been given to the Honorable Governor, my Lord. Kindly see the 6th schedule, my Lord, and more particularly paragraph 3 of 6th schedule, my Lord. The Regional Council, paragraph 3, my Lord, Regional Council for an autonomous region in respect of all areas within such region, and District Council for an autonomous district in respect of all areas within district, except those which are under the authority of Regional Council, if any, within the district, shall have power to make laws with respect to items, my Lord, are given. Allotment, occupation, use, and setting apart of land, my Lord, that is item A. Then B, management of any forest. C, use of any canal, water. So these are the subjects, my lord. And kindly see sub-para 3. All laws made under this paragraph shall be submitted forthwith to the governor, and until assented to him, by him, shall have no effect. So the laws made by district council, my lord, are required to be placed before the governor. And this provision, my lord, paragraph 3, sub-paragraph 3, is not similar to Article 200, my lord, where the governor has 3 options: assent, withhold assent, and refer it to the president, my lord. In respect of these subject matters, my lord, governor will act on the aid and advice of the council of minister, either to give assent or not to give assent, my lord. There is no question of reference, my lord. Here, so my submission is, my lord, wherever the constitution wanted to provide the power to the governor to either grant assent or not to grant assent in unequivocal terms, it has said so.
That has already been argued at least
Yes, my lord.
1 dozen times. I don't know.
So
If you want to add something new, you may add.
yes, my lord, in the context of paragraph 3, my lord, because in paragraph 3,
Paragraph 3 is not for consideration before us.
yes, my lord, so
We are not we will be answering only what are the questions which are referred to us.
yes, my lord, and paragraph 9, where the governor is exercising,
That provision is not for consideration before us.
my lord, what,
We have to answer what is referred by the Honorable President to us.
yes, my
We
lord.
can't open a Pandora's box.
No, my lord, what I'm trying to submit, my lord, is in the context of Article 200, my lord, if your lordship will see the Article 200 talks about a marginal note assent to bill. If your lordship kindly see Article 200, it's the marginal note is also a key to understanding
Yes,
the.
for interpretation.
Now, your lordship kindly see the
When
marginal.
when the provisions of when the text of the article is very clear,
Yes, my lord.
do we need to go to the margin?
No, because what the issue
No.
which,
It's an additional aid.
yes, my lord, it's an additional aid.
When we cannot interpret the text as it is.
Yes, my lord. Now, what my submission is, my lord, this aid is required to be.
What is the first principle of interpretation?
The first principle of interpretation is that the text is clear, my lord, then we'll have to go by the text, my lord. Now, the question which is falling for your lordship's consideration is that whether assent to bill has got 3 options or 1 option. Now, because if your lordship will see the marginal note of Article 200 is assent to bill. The marginal note is not saying consideration of bills, my lord. So the 2 other options, my lord, 2 other options, withholding the assent and referring it to the, or for reservation, referring the bill for consideration of president, my lord, are also, in my humble submission, my lord, are relating to the issue of assent to bill. Because this is in.
So what is your proposition?
My proposition is that the Article 200 provides for one option, that is assent to bill. And why do I say so, my lord? Is the reason is, my lord, that the issue, my lord, he assents to bill or he withholds the assent. Now, withholding the assent is for the purpose of formulating the message to the assembly, my lord, and after the message is sent to the assembly, then again the governor has no option but to give assent. So the marginal note, my lord, assent to bill, that is the only.
That is what everybody is arguing, that
No,
he has no other option
yes, my lord.
than to send it to the legislature with a message.
Yes, my lord.
And after that, if the legislature again passes the bill,
Yes, my
he has no other option than to get a grant action.
yes. So placing my argument forward, my lord, because if the governor had 3 options, withholding the assent, my lord, it is part of the larger.
So according to you, also, the withholding is for a limited period,
Yes, my lord.
which enables him to send the bill along with the message to the legislature.
Yes, my lord.
And after it comes back from the legislature,
Yes, my lord.
as it is, then he has no other option than to.
So assent to the bill, my lord. So then this is also an assent only to the bill, my lord.
That's the integral part of the assent only.
This is.
It's a comprehensive this thing.
Yes, my lord.
Assent first exercises well and good, otherwise second and third are also part of granting assent later on
Yes, my lord.
by following that procedure.
Yes, my lord.
Either reserving it for the president or sending it back to the legislature.
I'm grateful, my this is my precise argument
Because
that,
of the marginal note that assent to bill.
yes, so,
Assent to bill is the very essence of the provision,
yes, my lord.
not withholding of it.
Withholding or consideration of bill, my lord, also, because the marginal note would have said consideration of bill. But marginal note is saying assent to bill. So in my humble submission, it is a key to understanding these three aspects of the matter, my lord. So this is on the assent to bill, my lord. And my lord, if your lordship will see the second part of the Article 200, my lord, because if lordship will, the reference to the president also, my lord, a reference to the president. And there are three aspects, if your lordship will notice, in the first proviso of Article 200, the expression used is as soon as possible. But in case of Article 200, my lord, no such 201, no such exigency has been attached with the president to issue direction to the governor to return the bill. As soon as possible, my lord, is not mentioned in Article 201. So there is, my lord, so far as the reservation of bill is concerned, my lord, to the president, no such expression is used, my lord, regarding as soon as. Now, my lord, the point which I am trying to make, my lord, that as soon as the expression used as soon, in certain cases, my lord, for example, in 201, your lordship, kindly see 201. 201 says, my lord, when a bill is rejected, especially second proviso, my lord, 2002 provided further that governor shall not assent but shall reserve for the consideration of the president any bill which in the opinion of the governor would if it became law so derogate from the powers of the high court so as to endanger the position which the court is of the opinion court is by the constitution designed to fill, my lord. Now in respect of this aspect, my lord, if your lordship will see, when a bill is reserved by the governor for the consideration of president shall declare either that they assent to the bill or withhold assent therefrom. Here, my lord, message is in proviso, provided where the bill is not a money bill, president may direct governor to return the bill. Here there is no use of expression as soon as. Whereas in the case of Article governor, my lord, expression used is as soon as, showing the expediency in matters which are not reserved for the consideration of the president. So there are certain areas, my lord, there are certain provision which can be reserved for the consideration of president, my lord. Articles are, my lord, which are Article 31A. I will not read those articles, my lord, because those have been placed. 31A, my lord, your lordship will kindly see 31A. And proviso particularly, my lord, because under these articles, the bills have to be reserved for the consent of the president. Article 31A, my lord. Proviso, my lord, provided that where such law is made by the legislature of a state, provision of this article shall not apply thereto unless such law, having been reserved for consideration of the president, he has received his assent. So 31A, my lord, then 31C also, my lord. Provided where there such law is made by, it's a, then, my lord, 254(2) also, my lord, if lordship will kindly see 254(2), because the governor, if it is taken, my lord, is bound by the aid and advice of council of minister, and the bill is passed by the legislative assembly, it is passed by the party which is in power, my lord. So if there is no discretion vested with the governor on this issue, my lord, 254(2), then the advice would by the council of minister to the governor would be not to place it before for reserve the bill for the assent of the president, my lord. So therefore, certain exceptions have been carved out, my lord, particularly 200, Article 200 proviso 2, my lord, and that 31A, 31C, and 254(2) also, my lord, where a law made by the legislature of state with respect to one of the matters enumerated in concurrent list contains any provision repugnant to the provisions of earlier law made by parliament or an existing law with respect to that matter then the law so made by legislature of state shall, if it has been reserved for the consideration of president and has received the assent prevail in that state, my lord. So Mr. Reddy was placing this 254(2), my lord. So for the 254(2) also envisages the reservation of bill to the president, my lord, and also under Article 288(2), my lord. The exemption from taxation by a state in respect of water or electricity, my lord, and the legislature of a state may by law impose, and then Article 288 also envisages reservation of the bill by the honorable governor to the president, my lord. And last article, my lord, is Article 360, sub Article 4(a)(2), my lord.
Yes.
Yes, my lord. Article 364, sub-article 4, notwithstanding anything in constitution. Now, in the context of any such direction, it regard to, and the bill can be reserved for consideration. A small Roman 2, a provision requiring all money bills or other bills to which the provision of Article 27 apply to be reserved for consideration of president. So in all these matters, my lord, so there is no time limit, my lord. And as the expression in Article 201 does not contain as soon as possible, my lord.
Yes.
So my submission is, my lord, that the matters which fall exclusively in the domain of the president, my lord, no timeline has been set in Article 201. But the matters where,
So according to you, insofar as governor is concerned, the timeline is there.
yes,
Insofar as president is concerned, there is no timeline.
in respect of these matters, my lord, the items which are covered under the constitution, my lord, the inaction may not be there, my lord. Inaction in deciding one way, because the constitutional inaction is also a kind, there will be some decision on those aspects, my lord, but there is no timeline, strict timeline. Because, my lord, if I was going through the Hindi part of the Hindi version of the constitution, my lord, and in Hindi version of the constitution, what I found, my lord, the expression used for as soon is yatha sigra. Yatha sigra, my lord, is, if correctly translated, my lord, it forthwith.
Yeah, what did you say? Yatha se.
Yatha sigra. Yatha sigra.
Yatha shigra. Shigra matlab jaldi, yatha.
Yatha sigra.
Forthwith.
If I so, my lord, the Hindi
As soon as possible.
as soon as possible, forthwith.
Stronger this thing, forthwith.
I think, my lord, nothing turns on it, but yatha shigra possibly is as soon as possible. Forthwith, I'll just find out the Hindi word for forthwith, my lord.
So the
Turant, my lord, my learned friend is saying.
That's Hindustani.
But subject to, my lord, correct.
तुरंत प्रभाव से.
Pardon, my lord?
Official language, normally the word used is तुरंत प्रभाव से.
Turant, yes, tatkal prabhav se, yes.
so
With immediate effect. The kal prabhav se, with immediate effect.
With immediate.
जितनी जल्दी हो सके, my lord, that the yatha sigra not is जितनी जल्दी हो सके, as soon as is जितनी जल्दी हो सके, my lord. And yatha sigra, in my humble submission, is forthwith. So if I can please, my lord, unfortunately it is not part of my written
The
submission.
Constituent Assembly debates are in English, so while interpreting the words, we'll have to go by what is the text in the English.
Yes, my lord, but this is also a tool to interpret, my lord. This is also an aid to interpret.
Translation, which is the judgment shows that the translated version is a judgment of interpretation.
Yeah,
Shows a judgment.
yes, my lord. This is
Any judgment which says that the translated version of a statutory provision is an external aid for interpreting that provision.
no, the point which I was trying
You
to.
are saying that it's an aid for interpretation, so
No, my lord,
first one judgment will.
no, my lord, in larger context, my lord, in larger context, my lord.
India version is an aid to interpretation. Yes.
Yes, we are also saying as soon as maybe is forthwith.
Yes.
We are also-
Issue versus persistent translation. How can there be an aid to interpret?
Yes, Mr. Ambedkar.
Yes, Lord. Now, my lord,
You give a written notes, we'll
yes,
consider.
my lord, one more point, my lord. 145.3, my lord. Kindly see my written argument, my lord, on 145.3, my lord, because that at page 336 of my written argument, my lord. No, on this-
So far he's on the right side.
Huh?
I said, so far he's on the right side.
Written notes, at what page?
Yes, page 337, my lord.
Because having volume 2 point.
Volume 2. Volume 2. Volume 2.
Yes.
Your lordship will now under there, my lord, according to my lord, paragraph 80, my lord, the honorable, when hearing an appeal is obliged to refer any question involving a substantial question of law as to the interpretation of constitution to larger bench, provided two conditions are satisfied. First, this honorable court must be satisfied that the issue in question indeed raises a substantial question of constitutional interpretation. Second, it must be satisfied that the resolution of that question is essential for disposal of the appeal. Once both limbs of this test are met, the proviso use of the term shall render the referral mandatory.
This is with regard to maintainability.
Yeah, on with regard to the reference of that 140, whether it is 145.3, it is to be referred to 5 judges bench when the question.
Yeah,
In-
guys are not considered by the.
Yes.
Yes, it is in the context of my lord, the whether.
What is your proposition? You tell
My
us.
proposition is when the issue relating to interpretation of the constitution arises, my lord, it should be referred to the larger bench. It should be referred to 5 judges bench, but only on.
For that argument, you have to be on this side.
My lord, on this, because that is, I am in middle, my lord.
You are neither here nor there.
And on middle, my lord,
Support.
because I
Fairly.
borrow the words of learned solicitor. It is not adversarial because learned solicitor started the entire discourse with this submission that it is not adversarial. And we are assisting your lordship to come to the right conclusion, my lord. And so I have cited 2 judgments on this, my lord. Kindly see. And the Supreme Court rules also, paragraph 82, where Supreme Court rules are there, my lord.
Order 622.
Yes, paragraph 82 at page 338. Where during the hearing of any cause, appeal or proceeding, a bench considers that matter should be dealt with by a larger bench, it shall refer the matter to the Chief Justice, who shall thereupon constitute such a bench for hearing of. The repeated use of term shall in both the rules and enabling provision imparts mandatory force to the referral process, leaving no room for.
Anyway, we are not going to into that question whether the division bench ought to refer it to a larger bench or not. That's not an.
So, my lord,
Question
your lordship has considered this aspect in 2 judgments, my lord.
We are not considering that question as we are not on the correctness or otherwise of the judgment of the division bench as to whether they were not justified in referring it to a larger bench or not.
Because, my lord,
We are only answering the reference.
my lord, so
Yes, thank you, Mr. Amit, for it.
I'll place, my lord, my written arguments on this.
Yes, Mr. Wilson,
Yes,
10 minutes each.
yes. Grateful to your lordship, my lord. My lord, petitioner always, my lord, thinks of, my lord, participation in these types of matters. My lord, in order to assert, my lord, the state's autonomy and federalism. My lord, I'm grateful to the learned Solicitor General, my lord.
Even otherwise, we are going to forgive.
Yes,
We will
grateful
be
to,
grateful to you.
yes, grateful.
Then if
to
you are going to
Yes,
admit others,
yes, my lord.
at least because
Yes.
of the live streaming, then
Lord, I have filed my written submissions.
yes.
Lord, I have divided into 2 parts. Lord, page number 1 to 11, my lord, is a key to my written submissions. Volume 2.14. 14. Lord, this article, Lord, we have been wandering in this court for a longer period. Lord, we have brought this special reference. And my lord, we know the pain which we have undergone, my lord, in approaching the courts and ultimately, my lord, getting an order in our favor. My lord, that is why, my lord.
We are not going into
Yes.
the correctness
Yes.
or otherwise of the judgment
Certainly,
of the
my lord.
division.
Certainly, my lord,
We are only
I do-
restricting ourselves to the
Yes,
question.
I bow my head, my lord. I am grateful to your lordship, my lord.
So don't,
Yes,
Personalize it.
don't
yes.
bring your pain before the court.
My lord, whatever may be, my lord, today the states are celebrating this judgment. That's what I wanted to place it.
This is again,
My lord, yes. Now, my
You
lord,
are-
let us see the legislative procedure. Yes,
When you argue a matter, it is expected that you
yes.
argue a matter with some sort of
Yes, my
detachment.
lord. Yes, certainly, my lord, certainly. My lord, I have to just place, my lord, what has made us, my lord, to come before this court. Now, my lord, legislative procedure, this article 200 and 201, my lord, falls, my lord, under the heading of legislative procedure. My lord, this legislative procedure, my lord, should be understood in the context of the Constitutional Assembly debates, rule of law, and, my lord, the principles and approaches adopted by the constitutional courts. My lord, therefore, this legislative process, my lord, which your lordship is going to interpret, my lord, your lordship has to take into consideration that the people's, my lord, elect a government, my lord, or a representatives, my lord, with a fond hope that they will give good governance within 5 years. Therefore, my lord, the legislative process should be fair, reasonable, uphold legislative supremacy, respect states' autonomy, support the federal structure, and promote parliamentary democracy. My lord, that is what, my lord, this 200, my lord, altogether, my lord, your lordship has to look into it. So therefore, my lord, if your lordship sees how, my lord, Article 21, when the word, my lord, procedure, my lord, is there in Article 21 is interpreted by this court in Maneka Gandhi. My lord, I have stated that, my lord, in B. My lord, if your lordship sees, I have enclosed that, my lord, in page number 11, internal page number 11, 1506. My lord, Maneka Gandhi's case, my lord, clearly says, my lord, at page number 1507, that the procedure should be fair, transparent, and, my lord, addressing the functions of the governor, time limits and methods of handling bills, including reserving them for the president's consideration and setting time limits for the president's action in terms of constitutional scheme falls well within the jurisdiction of this constitutional court and judicial manageable standards envisaged in the constitution. The Honorable Court is tasked with the ensuring that both the procedural and substantive validity of any legislation align with the constitutional provisions. This includes interpreting the relevant procedures clearly and ensuring the effective functioning of constitutional institutions, not constitutional institutions including governor. This in turn enables the upholding of rule of law, delivering good governance. That's very important. For a people, we go before the people, we get elected, we come, Lord, and form the government, and Lord, we have to, Lord, give good governance. Lord, that is very important, and within 5 years, Lord, we have to do it. And therefore, Lord, there's a meaningful participation by the representatives of the people. These elements are essential for maintaining parliamentary democracy. Therefore, this Honorable Court is well within the time limits to interpret the legislative procedures embodied in Article 200 and 201 as exercised by the Governor and the Honorable President. Then, my Lord, I have also said, Lord, at C, paragraph C, Lord, in my key to the written submissions, Lord, page 1497, a judgment of this court, my Lord, in Roger Matthew versus South Indian Bank Limited. My Lord, if your Lordship sees, my Lord, page 12, I have extracted that judgment. Kindly see, my Lord, page 12, 1507, para 11. My Lord, in Roger Matthew, whether, my Lord, the court can go into the legislative, test the legislative procedure. My Lord, this court said, Lord, paragraph 11, I have extracted. Since the Constitution explicitly provides a self-contained detailed procedure for enactment of legislation and does not suggest that mere assent of the President to a law by whatsoever method adopted would become a valid law, it is necessary that this court, being the highest constitutional forum for judicial review, is provided with enough space for enforcement and protection of the constitutional scheme. Thus, a mere presidential assent does not validate a law by any method. The Honorable Supreme Court, being the highest constitutional forum for judicial review, must be provided with enough space for enforcement and protection of the constitutional scheme. Then, my Lord, I have also, my Lord, quoted Kaiser Hind my lord, 2002, 8 SEC, page 182.
Roger Matthew is with regard to the power of this court to examine whether the law violates any of the provision of the Constitution or not.
Not, my lord, including the procedure, my lord, which is set out in the Constitution. My lord, because the procedure, my lord, 200 and 201 comes, my lord, under the heading procedure, legislative procedure. My lord, my humble submission would be, my lord, this court is empowered, my lord, to see whether the procedure which your lordship is going to, my lord, interpret as per the constitutional debate, my lord, is fair and reasonable, so that, my lord, it takes into consideration all aspects. Then, my lord, this Kaiser Hind also, my lord, if your lordship sees page number 11, my lord, paragraph 12, my lord, I have extracted this Kaiser Hind. My lord, that relevant paragraph, my lord, at page number 12, at paragraph 12, my lord, paragraph 29, my lord, it says, we further make it clear that granting of assent under Article 254(2) is not exercise of legislative power of the President, such as contemplated under 123, but is part of the legislative procedure. Whether procedure prescribed by the Constitution before enacting the law is followed or not can always be looked into by this court. Therefore, my lord, the granting of assent is not exercise of legislative power, such as contemplated under the Constitution, but it's a part of legislative procedure. And my lord, held that the procedure prescribed by the Constitution before enacting the law is followed or not, my lord, court can always look into that. Then, my lord, with regard to the immunity, my lord, at page number 1497, my lord, my lord, I have said about the Rameshwar Prasad 2006 2 SEC, page 1, my lord, where immunity available to the governor does not take away the power of the court to examine the validity. Then, my lord, I have also extracted S.R. Bomey's case 1994 3 SEC, page 1, where, my lord, judicial review is a basic feature of the Constitution. The arm of the court is long enough to reach injustice, and actions of every highest constitutional functionary is subject to judicial review. And if your lordship sees, my lord, state of Rajasthan, my lord, that I have extracted, my lord, at page number 14. If your lordship sees, my lord, page number 1509, para 15, the state of Rajasthan is very important, my lord. Para 149 particularly, it says, this honorable court held that whenever a question arises as to whether a constitutional authority has acted within or exceeded its powers, it is a constitutional duty of the court to decide it. The Constitution is the supreme law of the land, binding on every organ of the government, executive, legislature, and judiciary alike. No authority, however high, can be the sole judge of the extent of its power under the Constitution. This court, as the ultimate interpreter, is entrusted with the task of defining the limits of power, ensuring that no branch transgresses them, and upholding the rule of law by enforcing constitutional limitations. Then, my lord, I have also extracted this Roger Matthew. Again, my lord, with regard to the interpretation of Article 212, my lord, to what extent, my lord, the court can go into the legislative procedure. My lord, if it is illegality, then, my lord, the court said, we will go into that. I have extracted, my lord, in page number 14. And so far as the judicial review is concerned, my lord, I have extracted, my lord, the judgments of this court, my lord, in fact, my lord, from paragraph 17, my lord, at page number 15, my lord, I have made a tabulations, my lord, S.R. Bomey's case, BP Single's case, paragraph 17, if your lordship sees, my lord, S.R. Bomey's case, BP Single's case, Kalpana Mehta's case, Rajaram Pal, State of Rajasthan, A.K. Kaul, Kaiser Hind. My lord, in all areas, my lord, there the judiciary, my lord, has interpreted, and that's how, my lord, the institutions are functioning. My lord, this is an area where, my lord, till, my lord, this Tamil Nadu state was Tamil Nadu governor fixing the deadlines. My lord, it was an area, my lord, where it was subject to interpretation. Now, my lord, that area is also settled. Now, if your lordship comes to, my lord, the questions, my lord, that is posed, my lord, by the honorable president, my lord, so far as question number 1 and 2, my lord, please come to page 3, my lord, of my keynotes. My lord, extent of power given to the governor. My lord, we are here, my lord, quoting Dr. B.R. Ambedkar's, my lord, speech. My lord, if your lordship comes to page number 18, my lord, I have quoted B.R. Ambedkar's speech, my lord. Where, my lord, he says, my lord, at page number 18, para 20. But where he says, yes, my lord, kindly come to 21, my lord. My lord, this is what, my lord, we expect. My lord, in fact, an assurance is given by my lord Dr. B.R. Ambedkar, my lord, when all states were coming together. The drafting committee felt, as everybody in this house knows, that governor is not to have any kind of functions. To use a familiar phraseology. Yes. Lord, this word was not read, that's why.
Only
It is read, my lord, then I'll skip it, bro. Grateful to your lordship, my lord. Then, my lord, your lordship kindly come to, but how this article, my lord, 175 and my lord, 91 was made, my lord, much argument is made. My lord, I am skipping that, my lord. And my lord, my submission would be only that, my lord, there are only three, my lord, ways, my lord, where it was argued much, my lord. And my lord, always the governor has to act under the aid and advice of the Council of Ministers. Now, my lord, with regard to the false through, my lord, much argument was made on the basis of, my lord, Alluri Basavia Chowdhury. My lord, our submissions would be, my lord, the bill falls through means bill dies where it is born. My lord, governor cannot withhold, my lord, bill on his own and bury it at Rajbhavan. My lord, as explained in the Constituent Assembly debates, it can be only exercised under the aid and advice of the Council of Ministers. And, my lord, why it is, my lord, sent back, withhold is, my lord, to remedy a hasty action, or when the ministry or the government changes before the bill is assented by the governor and a new ministry is
That is
formed.
already argued.
Yes, that is argued. My lord, in fact, Samshir Singh, Nabam Rabia, my lord, Kaiser Hind says, my lord, at page number 35, kindly see, my lord, page number 35. My lord, this is a page number 35. Lord, they say, Lord, will is nothing but expression of political will. Apparently, the will of the people expressed through the legislation passed by their elected representatives. To that extent, Lord, I'm quoting this. And, my Lord, the governor, my Lord, he can't be a constitutional court, my Lord, that we have, many of them have argued. Now, my Lord, your Lord should kindly see one of the important submission is, my Lord, this federalism, Lord, ingrained into the constitution. Lord, what Dr. Ambedkar said, if your Lordship comes to, Lord, page 37, Lord, I have extracted, Lord, Dr. Ambedkar. Our fear is, Lord, whether the federalism or a state autonomy is going to be lost. Lord, in the exercise of, Lord, interpretation of Article 200, kindly see, Lord, paragraph 40, what Ambedkar said. Lord, this is on 26th November 1949.
25th.
There is only one point of constitutional import to which I propose to make a reference. A serious complaint is made on the ground that there is too much of centralization and that the states have been reduced to municipalities. It is clear that this view is not only an exaggeration.
Already, we have read it so many times.
This is not read, my lord.
It is read.
Yes, my lord. Then I skip that, my lord. Then your lordship kindly, yes. Then your lordship kindly see, my lord, the time taken by the bill.
Where after Ambedkar says that insofar as states are concerned, they have an exclusive right to legislate on them.
Partition, the power is partition between the state and the central.
Parliament is concerned. This has been read so many times now.
Yes, and my lord, how the constitution has to work.
You had your 10 minutes
Yes,
now.
Lord, I will finish it off, Lord. But if your lordship sees, Lord, the constitutional silence, Lord, courts have interpreted, Lord. Yes.
Mr. Wilson, the only new thing which, of course, no one has referred to is your diagram at 1527. So better you rely on that.
Grateful to your lordship, Lord.
Colorful also.
Colorful.
A colorful diagram, Lord. Yes, Lord. Lord, I will just skip, Lord, certain points. I'll summarize. Lord, I have said about the constitutional silence, Lord, which your lordship can interpret, Lord. This has been said in Krishna Kumar Singh, Jai Shri Ram Patel, Kesavananda Bharati, and K.S. Puttuswamy, my lord. This court has said, constitutional silence is a dark matter like dark matters in physics. These elements are not directly observable in the text, but without them, the constitution would collapse in incoherence. Lord, that paragraph, my lord, I have marked, my lord, page 46. Then, my lord, I have extracted, my lord, the judgments, my lord, where they said about the constitutional silence. And, my lord, because of this Article 356 interpretation in S.R. Bomai's case, today, my lord, we are saved, my lord, from indiscriminate dismissal of the, my lord, by the governors. And, my lord, if your lordship sees, my lord, this as soon as possible, my lord, the interpretation, what H.V. Kamath feared, my lord, that is a fear coming to us, my lord. That is a fear, my lord, that I've my lord, stated in page 53, my lord, para 56. My lord, what will happen, my lord, if the timeline is not fixed? Then, my lord, I will be, my lord, wandering in courts. I have given a schematic diagram also, my lord. My lord, therefore, my lord, the court cannot be a mute spectators, my lord, and I cannot, my lord, court cannot be one of the layer between the governor and the act coming into force. Every time, my lord, I cannot come, my lord, I filed a writ petition in 2023. I'm giving one example. My lord, and 2025 only, my lord, the judgment was delivered. Nearly 2 years, my lord, I was wandering in the courts. Therefore, my lord, my humble submission would be, my lord, this timeline also, if your lordship sees, there is already a memorandum, my lord, which we have enclosed. Your lordship would kindly see, my lord, that memorandum at page number, Lord, 1551. This memorandum is extracted, my lord, in the judgment of Tamil Nadu government versus Tamil Nadu governor's case. This memorandum, my lord, passed by the central government, clearly says has got the approval of the cabinet, which says 3 months, my lord, the bill has to be disposed of. My lord, I have, my lord, enclosed at page number 1551. My lord, when the government itself, my lord, have decided to decide, my lord, all the bills within 3 months, and cabinet has approved. My lord, when cabinet has approved, my lord, it has got a flavor of Article 73. My lord, it becomes a law. My lord, what is difficulty now, my lord, in court saying that, my lord, within 3 months the bills have to be disposed? Therefore, my lord, they will not have any difficulty, my lord, in dealing with this because they already have a mechanism like this, but they are not doing it. Page number 1551, my lord, I have extracted that. So, therefore, my lord, my humble submission would be that the advisory jurisdiction, my lord,
Yes, yes. Mr.
advisory, my lord, I am concluding.
Yes, you are
Concluding,
you are
my lord.
done.
Advisory jurisdiction, my lord. Only when, my lord, there is a law that arises for consideration, my lord, the president can refer it under 143(1). But here, my lord, there are list of laws, my lord, I have enclosed a list at page number 70. Kindly see, my lord, page number 70. All questions, page number 70. My lord, I have given a tabulation. My lord, Tamil Nadu government versus Tamil Nadu governor is a complete answer for all, including, my lord, other cases. I have given all, my lord, the judgments, my lord, the questions raised in, my lord,
Thank you,
by
thank
the
you, Mr.
president.
Thank you.
And, my lord, lastly, my lord.
Thank you, thank you.
Yes. Yes. And, my lord, this, so far as 91, my lord, when it was, my lord, debated, they say that similar, my lord, be applied to 175. My lord, why they say is, my lord, your lordship would kindly see these timelines. If the bill returned by the president, my lord, this is there at volume 28. My lord, this alone, your lordship may note it, my lord. My lord, why the timelines, my lord, was skipped, my lord, when Article 91 had 6 weeks? Yes, my lord, they wanted, my lord, the bill as soon as it comes back. Yes. My lord, therefore, my lord, my humble
Thank you.
submission would be, my lord.
We are granted to 10
Yes,
minutes. You have
Lord,
taken-
this judgment, my lord, that is in place, my lord, is really helping the states, my lord.
We are not concerned with the judgment. How many times we are telling
Grateful
you?
to you. All the judgments, my lord, I'm only referring to all.
How many times we are telling you?
Grateful to you.
Don't get so much personally.
Grateful to you, lord.
May it please, Lords. Lords, if your lordships could kindly have volume 2.13, that's 1.3. In the soft copy, maybe better if your lordships can access that, because when you tap on it, it'll take you to the appendix which has references on the soft copy, but otherwise the hard copy is fine now. There are a few points I have to make which have not been made so far. I'm not doing anything which has already been addressed. Can this be just handed up to you?
You are appearing for who?
There are two applications in which I'm appearing, which 176467 and 175970. One is an advocate, the other is a former DGP of police, both citizens, both wish to address your lordships on this. Yeah, I'm just handing up copies of this constitution, my lords, which has the previous provisions in the footnotes, which may be relevant.
You already have your,
I do it customarily before constitution.
every constitution based.
This is
So
latest.
how many copies we should keep?
I have done that. It's the latest edition. So if your lordship will just.
I can replace it with.
Yes.
My lord,
In fact,
if we look
this
at the first
particular
page,
edition,
if
this
you look at the
particular
first
edition,
page,
if
my
you
lord,
look at
it's a
the
very good.
left side, the first page, you'll see the quote of Justice Vivian Bose from BD Supply. It is
Lord,
very,
if
very
your
important.
lordship sees the first page, well, it's an amazing effort by him, my lord, no doubt about it. But a layman would understand that rather than Dr. Ambedkar, Mr. Gopal Shankar Narayan has written this constitution.
Or Mr. Rahul Gandhi. So, the lordships can just.
Yes.
Now, my lords, in the constitution, just to start, just see Article 145, subclause 4 for a minute. One 145.4. This has not been read to your lordships yet.
145.
145, subclause 4.
No judgment shall be delivered.
Yes, if I can read that. No judgment, the word used is judgment, shall be delivered by the Supreme Court save an open court. Lord Sir, my Lord the Chief Justice. And no report. Please note the word report. This is very critical to this entire exercise. And no report shall be made under Article 143, save in accordance with an opinion also delivered in open court. So the Constitution envisages from day one that what your lordships are doing now is not a judgment. It is a report based on opinion. Now, because it says no judgment shall be delivered, save in open court, and no report shall be made as far as 143 is concerned. So the advisory opinion is a report, merely a report. What flows from that is a little critical for the purposes of your answering those 14 questions. So this is in fact a recognition of what took place before the Constitution came into effect. The Constitution took Section 213 of the Government of India Act. It effectively copy-pasted Section 213 into Article 143. The only addition were on questions of fact. Questions of fact were not considered by the federal court in its advisory jurisdiction earlier. So what your lordships are doing now is a completely different jurisdiction from the jurisdiction your lordships embark on in 32, 131, appeals, 136, etc. It's a completely different jurisdiction. In that jurisdiction, your lordships are being asked by citizen number 1 for guidance. Now, the way under Section 213 of the Government of India Act, this was referred to is relevant, and I'll tell your lordships the reason why it's relevant. That if for a minute your lordships will see Article 374 of the Constitution.
Article
374. Subclause 2 of Article 374. All suits, appeals, and proceedings, civil or criminal, pending in the federal court at the commencement of the Constitution shall stand removed to the Supreme Court, and the Supreme Court shall have jurisdiction to hear and determine the same. And please note this, the judgments and orders of the federal court delivered or made before the commencement of this Constitution shall have the same force and effect as if they had been delivered or made by the Supreme Court. So, all those that were delivered by the federal court are effectively binding on this court by virtue of 374(2). The reason I mentioned this, and this is why I don't want to duplicate what has been said before, but I'm just flagging it. Mr. Datar yesterday mentioned the estate duties case, which was one of the 4 references under Section 213 heard before the Constitution came into effect under the Government of India Act. The estate duties case is very critical about what they say about advisory jurisdiction. There are effectively 3 judgments of your lordships which have dealt with what the advisory jurisdiction is and what the chapeau of that is. And the first one is the estate duties case then. The second one, so far you've had 15 references under 143 before this court. The very first one, Delhi laws, did not deal with the issue. But the second one did, which is Kerala Education Bill. So there are many passages of Kerala Education Bill which look at estate duties, look at what the scope is. That same aspect of what the scope of 143, Article 143 is then considered by your lordships in the majority in Ahmedabad St. Xavier's, 9 judges. Noted, in fact, in the majority of Privy Council, Privy Purses, which is 11 judges. Noted finally by Chief Justice Chandrachud, and this has been referred to in the special courts act, both Mr. Reddy and Mr. Datar have referred to. What they say across this swath is as follows. And if I can just show your lordship that starting point, that's all I want to show your lordship from this. Just see page 1369 of this compilation, page 1369. And if your lordships are looking at the soft copy, your lordships may click on Appendix 1. Just tap on Appendix 1, it will take you to 1369.
1369 of?
Of this same volume, my lords, my compilation. I put everything here.
Yeah, go ahead. 2.2.
1369. This is Chief Justice Spence of the Federal Court, my lords. My lord, the Chief Justice has it, 1369. The 19th
Yes.
page of the volume, yes. 1369. I'm reading from the bold portion, just the bold portion. It may be stated at the outset that when Parliament